A federal courtroom became the center of a political storm this morning after a judge issued a ruling that immediately sent shockwaves through Washington. This was not a recommendation. It was not a warning. It was not a suggestion that could be debated away in press conferences or delayed through public relations strategy. It was a binding federal order delivered from the bench in less than 90 seconds. 90 seconds. That is all it took for a courtroom proceeding to ignite a national debate about the limits of presidential authority and the reach of judicial power. The ruling was announced at 10:22 a.m. inside a federal courtroom where observers expected another procedural hearing. Instead, they witnessed something that transformed the conversation almost instantly. Judge Elena Vargas entered the courtroom, opened a single folder, and began reading. Before she finished, phones were already lighting up across the room. Attorneys were exchanging urgent messages. Staff members were rushing toward the exits. Reporters were filing breaking updates before the hearing had even formally concluded. What happened today is not just another political headline that will dominate the news cycle for 48 hours before disappearing. It is not another partisan argument destined to become background noise on cable television. It is a development that could shape the relationship between the executive branch and the federal courts for years to come. Yet there is something even more significant than the headline itself. Most major news outlets have focused on the obvious angle. A judge issues restrictions. Political figures react. Legal experts debate the consequences. That is the story everyone sees. But buried deeper inside the ruling is a section that could ultimately prove far more important than the headline that generated the attention in the first place. Hidden within the document is a mechanism that changes not only what was ordered but how that order may be enforced going forward. That is where this story becomes far more serious. To understand why today's ruling matters, you have to understand how we arrived here. 3 weeks ago, federal prosecutors issued a subpoena seeking financial records connected to an ongoing investigation involving the White House. At first, the dispute looked routine. Similar legal battles occur regularly in federal courts. Most are resolved through negotiation, compromise, or carefully structured agreements between both sides. This case followed a different path. The president's legal team had multiple options available. They could have negotiated the scope of the request. They could have provided partial compliance while continuing to challenge specific sections. They could have worked with the court to establish a timeline acceptable to both parties. Instead, they chose confrontation. An executive privilege claim was filed almost immediately. The court rejected it. A second deadline was established. The deadline passed. A contempt finding followed. Appeals were filed. Higher courts reviewed the dispute and upheld the lower court's position. Additional opportunities for compliance were provided. The conflict continued. At every stage, the dispute escalated. Every new challenge narrowed the available options. Every missed deadline increased the likelihood that the court would move beyond warnings and toward enforcement. That is an important detail because it explains why today's ruling did not emerge out of nowhere. Judge Vargas has overseen this matter for months. The deadlines were documented. The warnings were issued. The opportunities for compliance were provided repeatedly. The court's position is that every alternative was exhausted before today's action was taken. Which brings us to the ruling itself. The language used throughout the document is remarkably direct. According to the court, certain executive powers connected to this investigation can no longer be exercised without judicial review. In practical terms, actions that were previously handled exclusively within the executive branch now require oversight from the court. Supporters of the ruling argue that these measures are necessary because repeated non-compliance left the judiciary with few remaining options. Critics argue that the court has crossed a constitutional line by inserting itself into powers traditionally associated with the presidency. Regardless of where someone falls in that debate, one fact is impossible to ignore. The consequences are immediate. These are not symbolic statements designed to generate headlines. They are operational restrictions that affect how decisions connected to the investigation can be made from this point forward. The presidency continues to function, but several authorities that have traditionally been exercised independently are now subject to judicial review. And what happened inside the courtroom may be just as significant as the language contained in the ruling itself. Judge Vargas offered no lengthy explanation, no dramatic remarks, no extended discussion. She entered, read the summary, announced that the order would take effect immediately, and left. The entire process lasted roughly 90 seconds. That speed was not accidental. In federal litigation, timing matters. Delays matter. Minutes matter. By moving quickly and making the order effective immediately, the court ensured that the compliance clock began running before emergency legal challenges could slow the process. Within minutes, appeals were already being prepared. Within hours, political leaders were issuing statements. And across Washington, legal experts were beginning to debate a question that could define the next phase of this confrontation. How far can judicial authority extend when a court believes its orders are being ignored? The answer to that question may determine not only the outcome of this case but the balance of power between the branches of government for years to come. The moment Judge Vargas began reading, the atmosphere inside the courtroom changed. At roughly the 40-second mark, Trump's lead attorney reached for his phone. Two junior lawyers were already moving toward the hallway before the judge had even completed her final sentence. What happened next was just as important as the ruling itself. There were no questions. There was no discussion. There was no invitation for either side to respond. Judge Vargas simply closed the folder, stated that the order would take effect immediately, rose from the bench, and exited the courtroom. That speed was not accidental. It was deliberate. And understanding why it was deliberate is essential to understanding the significance of everything that followed. In federal litigation, there is often a brief but critical period between a ruling being announced and the ruling being formally entered into the record. During that window, attorneys frequently move quickly to request emergency relief. They stand, address the court, and ask for an immediate stay while appeals are prepared. It happens constantly in federal courtrooms across the country. Judge Vargas effectively eliminated that opportunity. By the time Trump's legal team fully processed the scope of what had just occurred, the order had already been entered, the ruling had already become active, and the compliance requirements were already in motion. An emergency stay request was eventually filed, but not until 23 minutes later. Those 23 minutes mattered. Because during those 23 minutes, the court's order existed without any pending challenge. The compliance clock had already started running. Not when an appeal was filed. Not when another court reviewed the matter. The clock began the instant Judge Vargas declared the order effective. And that brings us to what may be the most significant section of the entire ruling. Page 38. This is the section that has received far less attention than the headline itself, yet it may ultimately prove to be the most consequential part of the document. According to the ruling, the court established an independent compliance mechanism designed to verify adherence to the order and report directly back to the judiciary. The significance of that move cannot be understated. The court did not simply issue restrictions and assume they would be followed. Instead, it created a framework intended to monitor compliance in real time. Supporters of the ruling argue that this step became necessary because previous court directives were repeatedly challenged, delayed, or ignored. Critics argue that such oversight represents an unprecedented intrusion into executive operations and raises serious constitutional questions about the separation of powers. Regardless of where one stands, the practical implications are substantial. The oversight structure outlined in the ruling would allow court-authorized review of activities connected to the matters covered by the order. Information relevant to the investigation could be examined, compliance could be verified independently, and any alleged violations could be reported directly back to the court. For many legal observers, that provision is the true center of the controversy. Historically, presidents have faced investigations, subpoenas, congressional inquiries, and even impeachment proceedings. Yet the concept of direct judicial monitoring of executive compliance represents a level of court involvement that many constitutional scholars consider extraordinary. That is why page 38 has become the focal point of legal debate. It transforms the ruling from a simple dispute over documents into a larger argument about the boundaries of executive authority and judicial enforcement. The political response began almost immediately. Within minutes of the ruling being announced, public statements started appearing. Criticism of the decision was swift and direct. The judge was accused of overreach. The ruling was characterized as unconstitutional by supporters of the president. The oversight provisions became a particular target, with critics arguing that they amounted to judicial interference in executive operations. At the same time, prosecutors pointed to those public responses as evidence supporting the court's concerns about compliance. That dynamic created a striking contrast. While attorneys were preparing formal legal challenges and asking higher courts to intervene, public messaging was moving in a completely different direction. Court filings emphasized respect for legal process and appellate review. Public statements focused on condemnation of the ruling itself. Legal analysts quickly noticed the contradiction. Because every public statement criticizing the order also became part of the broader narrative surrounding compliance and enforcement. What was intended as a political defense often ended up reinforcing arguments already being made by the opposing side. That pattern has become one of the defining features of this confrontation. Every attempt to challenge the ruling publicly creates new material for legal review. Every statement generates additional scrutiny. Every reaction becomes part of a record that continues to grow with each passing hour. And that is why the emergency appeal now carries such enormous importance. The central argument presented by the defense is straightforward. They contend that the ruling exceeds the constitutional authority of the judiciary and represents an unprecedented expansion of judicial power into areas traditionally reserved for the executive branch. Supporters of the ruling disagree. They argue that the court acted only after repeated failures to comply with lawful orders and after every lesser remedy had already been attempted. Those two positions are now on a direct collision course. The appeals process will determine whether Judge Vargas's order remains in effect, is modified, or is overturned entirely. But regardless of what happens next, one reality is already clear. This dispute has moved far beyond a disagreement over documents. It has become a test of institutional authority, constitutional limits, and the ability of the American legal system to resolve conflicts between its most powerful actors. And as the next round of legal battles begins, the consequences of today's ruling are only just starting to unfold. The emergency stay request argues that the ruling represents an extraordinary expansion of judicial authority and should be paused while the appeals process unfolds. That is now the central legal battle. But there is another reality operating alongside the legal arguments, and it may ultimately matter just as much. Every hour spent publicly attacking the ruling creates a new layer of evidence for those defending it. Every statement questioning the court's legitimacy becomes part of the broader discussion about compliance. Every public declaration of resistance strengthens the argument that the court's concerns were justified in the first place. We have seen versions of this pattern before. Legal confrontation leads to public escalation. Public escalation produces additional scrutiny. Additional scrutiny creates new legal consequences. The cycle repeats itself. The difference this time is that the court has moved beyond warnings and entered the enforcement stage. The mechanisms are already in motion. The oversight structure has already been established. The compliance framework is already being prepared. And that is why legal experts across the political spectrum are treating this as something far more significant than an ordinary courtroom dispute. To be fair, both sides of this debate deserve serious consideration. Supporters of the ruling argue that the court reached this point only after exhausting every other available option. One former federal prosecutor with nearly 2 decades of experience explained it this way. When a judge authorizes direct compliance oversight, that is not a routine judicial remedy. It is a measure reserved for situations where the court has concluded that every lesser remedy has failed. The argument from that perspective is straightforward. The record shows multiple court orders, multiple deadlines, contempt findings that survived appeal, repeated opportunities for compliance. Supporters argue that once those opportunities have been exhausted, the judiciary has a responsibility to ensure that its lawful orders are respected. From their perspective, oversight is not an act of aggression. It is the final available enforcement mechanism. But there is another side to this debate, and it raises concerns that cannot simply be dismissed. Critics argue that regardless of the facts of this specific case, the precedent itself carries enormous consequences. Former government lawyers and constitutional scholars have warned that allowing courts to place independent oversight mechanisms inside executive operations could permanently alter the balance of power between branches of government. Their concern is not limited to the current president. Their concern is every future president. Once a precedent exists, it does not disappear when a single administration ends. Future courts may point to it. Future administrations may be governed by it. Future constitutional disputes may be shaped by it. That is why critics argue that a short-term enforcement solution could create long-term constitutional complications. And that is what makes this moment so significant. Both arguments carry weight. Both arguments raise serious questions. But what separates this case from a purely academic debate is the documented record behind it. Months of legal proceedings. Repeated court directives. Missed deadlines. Appeals that were reviewed and rejected. Public statements that prosecutors argue demonstrate continued resistance. Taken together, supporters of the ruling believe the evidence justified extraordinary action. Critics believe the evidence still does not justify crossing a constitutional boundary that previous courts avoided for generations. At its